So I'd like to just introduce Norm right now. Norm Semanko.
All right, thank you. So Jeff has no idea what I'm going to talk about. That's I guess what he's suggesting to talk about. But no, I'm really appreciative of the opportunity to be with all of you again this year. Been coming to these every year, and freedom-loving folks in the area that I grew up in North Idaho. I always appreciate the opportunity to get together with you. Before I get going here, I wanted to mention a couple of things. First of all, Jeff's recount of how I got involved with the group is fairly accurate. But what really happened is I was contacted by the Idaho Farm Bureau. They knew that the North Idaho adjudication was underway, that the federal government had filed claims on behalf of the Forest Service and the Bureau of Indian Affairs to the Coeur d'Alene tribe, and they knew what a fight that was in southern Idaho, the Snake River Basin adjudication, and wanted to get folks involved. They had organized irrigation districts in southern Idaho to lead the fight to protect the water down there. We didn't really have that in North Idaho. And they knew that I'd been involved in the Snake River Basin adjudication, and they knew I was from North Idaho, so they asked if I could meet with a couple of folks up here, and Representative Judy Boyd also had asked if I could meet with some of the folks that were involved with the Farm Bureau locally, and some of the other groups like NWPOA, North Idaho Water Rights Alliance. So Carla Wepner, who's here, was one of those people, one of your longtime board members, and met with her and others at the fairgrounds here during the fair, Coeur County Fairgrounds. And we talked about, what is this thing? How do we get organized? What's going to happen? What do we need to do? And I assured them that if we were organized and we were focused and we worked with who should be our allies in this thing, the state of Idaho, and more on that in a minute, that we could make a real difference. That we could try to bludgeon or stop, halt, reduce the potential intrusion of the federal government, because that's really what this is about. We always talk about tribal this and tribal that. It's really about the federal government taking over more control of the property rights in Idaho. And never forget on your list here, number 7, water rights are property. They are real property under Idaho law. They're recognized in Idaho code that way, and they are real property. So that was what this was all about. So thank you so much to Carla for the leadership she took, for the rest of your board in getting involved in this. You are in this fight to protect your water rights, your property rights, your way of life against the United States of America, the government of the United States and their army of lawyers. And you are joined in this fight by North Idaho Water Rights Alliance, which is a similar group of folks in the more eastern part of this county and Benoit and Shoshone counties, by the Coeur d'Alene Lakeshore Property Owners Association, by the Hagedon Hospitality folks, who of course are right on the lake with the resort, and other interests, and also Raft and Power, concerned about impacts on our aquifer from federal control. All of those folks have been joined together in what we call the North Idaho Water Rights Group. And we have been on equal footing. All of you in this room that are involved with NWPOA have been on equal footing with the United States, the Coeur d'Alene tribe, the state of Idaho, and the others that are in this litigation over the last several years. I'm here tonight to report to you, I hope, that we're now in the end game, for those of you that are Avengers fans. That didn't just happen overnight. It was a couple of movies, finally get to the end game, and still the things going on. There's going to be more movies, right? But we are in the end game, I think, now. Because we had major litigation, which I was hoping I could report to you on this spring, but here we are this fall to talk about an opinion that was issued by the Idaho Supreme Court about this time last year. And this should get us to dinner. Okay? Little footnote here. Great to see the pledge. It reminded me of Lakeland High School, and we did the pledge every morning in homeroom. Do they still do that in high school? Do they still do the pledge in North Idaho? I hope so. It's been a long time since I've been at Lakeland High. I mentioned the state of Idaho. For those that have been involved in this, you know this. For those of you that haven't been, you need to know this. The state of Idaho is the primary objector to the federal and tribal claims. We have been there with them shoulder to shoulder, urging them on to take on the fight and to protect our water rights. But when they aren't quite in sync with us, we haven't been shy about tapping them on the shoulder and saying, hey, you need to look for this, or you need to do that. We would not have been able to do that, and I would like all the state legislators in the room to stand up, please. We would have never been able to do that without the guidance. Come on, you're in the room. North Idaho legislators, stand up. Thank you. So these guys can't talk directly about the conversations they have with the folks from the Attorney General's office, but these state legislators have been involved every step of the way in helping guide the efforts of the state in the courtroom, and it has been invaluable. We've been able to stay, for the most part, on exactly the same page. Now our focus, our emphasis, is a little bit different than the states, but very much working together. All right, so let's talk about this case. We're in the adjudication, where everybody who's got a well or a spring and has filed a claim knows what that is, and you got a recommendation in the mail, and nobody objected, hopefully, and you got a decree from the court. All right? The United States filed claims, just like you did, for the tribe. 353 claims for the lake, control of the entire lake, for all of the tributaries to have in-stream flows for fisheries, for irrigation, agriculture, for fish and wildlife purposes, for wetlands, for domestic purposes, and for commercial and industrial uses. Just a whole slew of different uses. And in their defense, they only get one shot at this. They only get one chance to file claims, so they max out what they can claim, right? And they filed this 353 claims. So everyone had a chance that was a water right owner to object, including folks in this room and others that are not. And that created the sub-cases that then spawned the litigation that ended up with a decision from the district court. The judge from Twin Falls came up to Kootenai County, held the hearing, summary judgment hearing at the courthouse. Some of you were there, and made a decision. We agreed with most of it. There were some parts of it we didn't like. There was enough in that people didn't like that everybody appealed some part of it. So you had an appeal by the state of Idaho on some of those fish and wildlife claims that could potentially impact water resources and availability for others. I'll talk about that in a second. You had an appeal by the United States, who didn't like 80 or so of the claims had been denied. The tribe basically filing the same appeal that the United States did. And then the North Idaho Water Rights Group, our group, North Idaho Interest, filing an appeal on some of the claims that were granted that we thought should be denied. We were focused, our concern, and I get this question sometimes, why do you care what water the tribe has on the reservation for their folks? Why don't you just let them have whatever they want? That's not the issue. The issue is when you insert into a state law system a federal law right for a flow in the stream that wasn't there before and is higher than was there, say, during the drought in 2015 or 16, somebody has to be shut off. First in time is first in right. So that's why we care. Our goal from the very beginning, from the very first meeting I had up here, was to protect our water rights, to protect our property rights from intrusion by the federal government. If the federal government has a superior right on a stream, on a spring, on the lake, that can shut you off during times of shortage, that fits so many of these categories. Regulations, federal land management, protection protection of your waterways. That's why we're in this. That's the focus, that's the prism that I look at this case through all the time. It's not about denying something to the tribe. It's about avoiding an increase in federal power and regulation over folks in this region. That's what it's really about. That's what we try to get this trimmed down to. So these 4 appeals were filed. 2 days of oral argument after mounds and mounds of briefing and I don't remember, 3,700-page record. This was on summary judgment. We didn't have a bunch of discovery. We didn't have a big trial. This was summary judgment on the legal issues of how many of these 353 rights are legitimate. How many of them get to move forward in the process and get a quantity attached to them so that the tribe has these water rights. So what was at issue? The district court, that's the judge out of Twin Falls, he specifically allowed reserved water rights for agriculture, irrigation, fishing, and hunting and domestic purposes. Now, important to understand here that this is based on federal law. What federal law says is that when a certain chunk of federal land is set aside for a specific purpose, i.e. an Indian reservation, a specific amount of water is reserved with that land to fulfill the purposes of that reservation. So why was that land set aside for the Indians? The judge said for agriculture, for fishing and hunting, and for domestic purposes, so I'm going to find that there's a water right for that. He also allowed reserved water right claims for in-stream flows within the reservation, but disallowed, and this was a big issue, those flows for in-stream purposes outside the reservation. And he also disallowed claims, including one for maintenance of levels for the entirety of Lake Coeur d'Alene. Very important aspects of the decision. So, in a 61-page opinion that ended up being issued by the Idaho Supreme Court last September, the court observed that it was wrong for the district court to limit the inquiry to specific purposes. What was the most important purpose? Why was a reservation created? We argued, the state argued, that the specific purpose that the reservation was created for was for agriculture. And there was a lot of support in the historical documents for that. So if they had any water rights, it would be for agriculture and the domestic needs associated with that. Not hunting and fishing. They were leaving that behind. That was yesterday. We were moving forward under the agreement and the reservation to agriculture. The court disagreed, the district court, and said, I find the primary purpose of the reservation to be all of those things, domestic and agriculture and hunting and fishing. The Supreme Court said, nah, that's not the way you should look at it. It isn't for the primary purpose. And I think they were concerned that if the primary purpose test applied, and that applies for all other federal reserves except for Indian reservations, then it would be a mistake to find multiple primary purposes. Primary means first in importance. There should only be one. So they went a different route. They looked at what Arizona and Montana and some other states had done, and they said the appropriate test for an Indian reservation is to recognize a broader homeland purpose. Not a primary purpose, a homeland purpose. And that homeland purpose includes, coincidentally, agriculture, domestic, hunting and fishing, and then they also added gathering and cultural purposes. I don't know what that adds in terms of water needs, but gathering and cultural are included. That's how the Supreme Court came down. Not a big advancement of the ball for the United States and the tribe from what they got in the district court. The big issues were these. The tribe and the United States lost on commercial and industrial uses on the reservation. On the reservation, no commercial industrial, because that was not the purpose for which the reservation was created. It's not part of the homeland purpose. The Supreme Court upheld that. Any commercial uses on the reservation that you're aware of? There is nothing about casinos or golf courses in the agreement with the tribe, the executive order creating the reservation in 1873, or the act that was passed by Congress in 1891. Big problem for the tribe coming out of the Supreme Court. They got no federally recognized, federal law-based, commercial or industrial water right. Now, does that mean the casino and the golf course are going to get shut down? No. But it means they don't have a federal water right for that. So just keep that in mind as we move forward since the decision. Second big issue, during oral argument in the district court room here in Coeur d'Alene, tribal attorney argued, you know, we won that case in the U.S. Supreme Court that said we own the southern third of the lake. But that case didn't really address the northern two-thirds of the lake. We still think we own that. And the district court judge said in a footnote, no, you don't. You ceded it, you gave it all up. The Supreme Court upheld that. They said the words in the agreement are unequivocal. You gave it all up. And I can read you the exact words, they're in the opinion. That was a huge decision because if they didn't waive the rights that they had off the reservation, their water right claims off the reservation would be recognized. Their ability to control the entirety of the lake, all of the tributaries that feed the lake throughout North Idaho would have been recognized. Folks, this decision in our favor was on a 3-2 vote of the Idaho Supreme Court. We were this close to losing on that issue. And the Idaho Supreme Court is basically, because of the way the system is set up, which is a good thing for us. We're not in the Ninth Circuit Court of Appeals. We're in the Idaho Supreme Court. That would be the last word except a potential permissive appeal to the U.S. Supreme Court. So that was a huge decision. 3-2 in our favor. A little surprised that the margin was that thin, but we'll take it. 1 point win works just fine. So you've got, but the other issue you had, and the one that we argued so strongly against, why did we care about hunting and fishing and whether that was a continued recognized purpose of the reservation? Because domestic use is on the reservation, and it just affects that localized, taking the water out of the ground for a well. And the same with the irrigation. For the most part, we know there's not that many acres that are going to be irrigated, so that's not a huge deal in our view. The big issue was in-stream flow claims. Because if you got to have so much water in the stream at any given time, including when there's a drought, people can't take water out. They got to leave it in the stream. That affects folks like you. Okay, so that's why that was huge. Off-reservation gone. They got no claim there. That's why that was so big. On-reservation, in-stream flow claims are for hunting and fishing purposes, to preserve fish, right? That's one of the reasons why we argued so hard against that. We lost on that. We lost in the district court. We lost in the Supreme Court. They have on-reservation in-stream flow claims. So, like Hangman Creek, okay? Those places. Well, for how much? And who's it going to affect? It's not going to reach through all of North Idaho, but it's going to affect certain tributaries. So, we lost something we kind of need because we don't want folks getting shut off during drought because of these federal rights now being brought into the system. And the tribe kind of misses something because they didn't get commercial and industrial uses. So as we close the book on the decision, now the question becomes, are we going to quantify the rights they did get and say goodbye to the rights that they didn't get? That's traditional litigation will tell you that's where we're going. Quantification of these rights, the United States knows, and the tribe knows, the state knows, and we know, would take 4 to 5 years. It is fact-intensive, expert-riddled, very intensive, long litigation, subject to appeal, on all these different categories of claims. What we have decided is we fought the fight, and we won on the big issues, the off-reservation, the control of the lake. We won on those. The other issues we should be able to work through. We should be able to figure out how much water for domestic, if it's really needed for irrigation, and some of these other uses the tribe really needs, and negotiate that. And in exchange, get some things that we need. So, for example, and this isn't telling you anything out of school, if you look at any number of settlements of Indian water right claims across the western United States, including in other parts of Idaho, you will see that in all cases, I think all cases, there's a concession by the federal government that in exchange for receiving what they get under the agreement, they they will not shut anyone off. They will subordinate. They will make their rights inferior to the existing rights. We need that. That's part of the negotiation that we're having. The tribe wants to somehow claw back, recognize the things that they lost, the commercial uses. You can see the nucleus for having a discussion about how to settle this. That's where we're at now. We've advised the court that we need time to talk. We don't want to enter into active litigation. We're not afraid to do it if we need to. We will be cheering the state on. They will be struggling with how to fund experts in the future if we go into litigation, and we'll be cheering them on. But much better in our view, and so far the discussions amongst the attorneys involved have been very productive. The better course is to try to work out an agreement that protects us while providing them with water rights in the future for the needs on the reservation. That's where we want to be. The issue was federal control. We beat back federal control of the lake and federal control of property off the reservation. Now there is an issue for property owners on the reservation. Not everything's owned by the tribe, right? Lands on the reservation are owned by private entities. That's part of working through, and frankly, the reason why we need to negotiate a settlement with regard to these in-stream flow claims, because they impact those people more than anyone else. So that's what we're doing. We filed a motion yesterday with the court. The state filed it, was unopposed, to ask until the end of January to continue these settlement discussions. We'll be in front of the court on Tuesday in a status conference to advise them of our progress. We have a concept paper that I shared with the contact points for all of the client group, including Jeff. And we've talked about that. I'm sure he shared it with his board. Do we agree with everything in there? No. But the four corners of that document are something we can live with. Everything within the four corners is kind of fuzzy right now. We've got to work through it. But we think we're on the right track. If not, we'll go back to litigation. But for right now, we have frozen the litigation on quantification, and we are attempting to settle. My goal always for this group and the others is to protect our property rights, our water rights in the settlement, non-negotiable. That is also a primary goal, by the way, of the state of Idaho, not only to protect existing water rights, but to allow potential for future growth as well. That's a goal of the state in this thing. And then secondly is to avoid, and we share this with all the other parties on our side of the case, to avoid additional regulation by the government, whether it's the federal government or the state government or a tribal government. We don't want more regulation over our property rights. That's the other guiding principle for us in the settlement talk. So that's what we're doing. That's what we'll continue to do. I hope I'm here next year reporting that we're done. There's a chance of that. We don't promise it, but I hope that's where we're at. With that, we've got to be ready for dinner now. Thank you.